Great. Thanks a lot, Kyle. So as Kyle mentioned, I'm one of the chairs along with Colleen Koch of the Boulder Bar Civil Litigation section. And today we're lucky enough to have all four of the judicial officers who are handling the civil litigation matters in Boulder District Court who will be presenting on what has become the topic du jour of valuable pointers for practicing in Boulder District Court under COVID-19 restrictions. Our presenters will be judges Patrick Butler, Bruce Langer, Andrew Hartman, and Magistrate Keith Collins, and they'll be providing insight and advice to helping you litigate in Boulder District Court under these restrictions, steps you could take to make life easier for judges and court staff, and practical tips for effectively litigating cases, including tips for trying cases virtually, motions, hearings, witness examinations, and the like. And they'll also perhaps lend insight into how things may be evolving in the court in the new year. Judge Butler was appointed as a judge in October of 2011. He was a magistrate in the 18th Judicial District, where he had worked since 2009, and was a partner at Lamb and Butler, where his primary focus was civil and criminal cases. He earned his bachelor's degree from Keene State College and his law degree from Gonzaga. Judge Hartman was appointed to the bench in 2013. Prior to that, he practiced commercial litigation for more than 20 years and received his undergraduate degree from the University of Michigan, his law degree from Georgetown University. Judge Bruce Langer was a former longtime prosecutor with the Boulder County District Attorney's Office, and he received his JD from the University of Colorado and also his undergraduate degree from CU before working for the Daily Camera. And Magistrate Collins was appointed as a magistrate in 2019. Before that, he was a part-time magistrate for the city and county of Denver, and he worked both as a deputy district attorney and founded his own law firm where he did criminal defense law. He received his undergraduate degree from Davenport University and his law degree from DU. So we have a good panel for you. We thank you all for attending and enjoy the presentation.
Thanks for the introduction. I was tasked with sort of giving the dry part of the presentation, which is sort of the local administrative orders. And we'll do that first before people fall asleep. And then the more lively part of the presentation is sort of the tips, practice tips and suggestions that we're going to give to folks. If you're not aware already, all of the local administrative orders are on the judicial website, but there have been a number of those that have come into play because of the COVID pandemic. And so if you're not familiar with them, I'm going to just point out a few of them. If you are familiar, great. At least one was updated just last week, so it's important to continue to try to stay up with those orders as they might be changing from time to time, depending upon the state of the health crisis, what the public health folks are telling us, and the restrictions that are put into place. So Local Administrative Order 20-107 requires facial coverings for everybody who comes into the Justice Center and to the Longmont Courthouse for either court or probation services. It is important that if you are coming in person, even if you're somehow coming to the clerk's office to file something, or you have clients going to probation, that they have a mask and that they wear it while they are in the Justice Center and the Longmont Courthouse. Local Administrative Order 20-108 relates to the FED procedural rules, forcible entries and detainer, and that was just updated last week. Those cases are supposed to be filed by the Wednesday, 10 days in advance of a Friday return date. Now, there was a cap in the Justice Center of 50 cases per week, and that's been changed to 25 cases as of December 7th. And of those 25, 5 could be pro se cases, 20 law firm cases. And no law firm, no single law firm shall file more than 10 cases in any given week. So if your practice is representing landlords or property owners, you should be aware of that. In Longmont, there's a weekly cap. It was 20, it's now 10 that can be filed in a week. And that's composed of 4 pro se, and no more than 4 of those being pro se, the remainder being firm filings. There are requirements of having an affidavit declaring whether the Coronavirus Aid, Relief, and Economic Security Act applies, the CARES Act. And you have to have certain documents attached to every summons, including the eviction mediation services available and preparing for eviction court landlords and tenants. The parties are being encouraged strongly, is the word that's being used, to mediate prior to even appearing in court. Local Administrative Order 20-109, it deals with limitations on certain debt collection practices. So if you have a practice that deals a lot with either creditor or debtor representation, you should become familiar with that as well, because there are some stricter requirements than were previously in place. And under the local administrative order, the clerk is directed to reject any writ or legal process that does not comply with the new procedures and already existing requirements. So it is, again, important, just know those orders so that you don't have to refile or have a pleading rejected. Local Administrative Order 20-111 is based upon the CDC and Department of Housing and Human Services eviction moratorium. Residential evictions were halted by reason of non-payment of rent between September 4th and December 31st of 2020. Now, that could be continued or extended by the chief judge if she determines that that's appropriate. There are also some other requirements with the eviction moratorium regarding filings and compliance with the administrative orders, because if not, again, there's sort of this directive that if you're not in compliance, the case shall either be dismissed or upon good cause shown, the return date shall be continued. And then the last local administrative order I want to chat about is Local Administrative Order 20-112, which is the temporary suspension of jury trials. There were, for criminal cases, no jury trials are going to be held, or even from back to when it was issued on November 5th, from November 5th through January 19th of 2021. If you follow the news, a couple of other jurisdictions in Colorado recently extended some of their jury trial continuances or suspension into February. I think our chief judge is going to wait to see if we get another uptick in the county over this next holiday sort of round between Christmas and New Year's. And if so, she certainly has the right, if she chooses to extend that suspension. But right now, all criminal jury trials have been suspended until at least January 19th. As far as civil jury trials, except for dependency and neglect trials, all civil jury trials are continued to dates on or after July 19th, 2021. And of course, that raises issues if you have a civil litigation practice of whether or not that's promoting additional settlements, or whether certain parties might use that as a sword or a shield in terms of trying to get folks to perhaps settle their cases for less money or sooner or whatever than they might otherwise, because they know they're not getting to trial all that soon. We are still holding court trials during all of this time. That includes civil, domestic relations, and criminal. Not that many folks have yet taken us up on our offers to change your jury trials to court trials, which I always find a little bit amazing. I realize in criminal cases, you want to try to get that 1 out of 12 if you got a particularly bad case to try to hang it perhaps. But in civil cases, obviously, you get a 6-person jury. But it's not really much different doing a court trial than doing an arbitration. And a lot of folks agree to arbitrations in their civil cases. So at least we'd ask you to consider whether or not you can get an agreement to do court trials. I know I have 3 set in January, and I'm really hoping some go, because we get rusty too if we don't have trials. And I haven't had a trial outside of domestic relations or dependency and neglect, termination kind of things in quite a while. Also, WebEx appearances are available until further notice. The jail, for folks who also do criminal matters, are certainly concerned about COVID conditions, and they're very reluctant to try to transport inmates over to court. And so we are handling as many of those cases as we can by video WebEx as well. So I've got just a few tips now, and then I'm going to turn it over to my colleagues to give you the real meat of everything. But here are sort of, Butler's top 10, if you will, of tips for practicing during a pandemic. If you don't know already, the virtual courtroom information is on the state judicial website, and each judge has their own room for hearings. And so we've been assigned a room, and that's the room number that you call into when you're set to have a hearing. So even if you were, for example, scheduled in Judge Langer's division, but the case got assigned to me, you'd be calling into my room for getting on to the hearing. Usually we send out notices that have the WebEx information on it. It does help to upload any exhibits that you plan to use ahead of the hearing. I have found that when they do the sharing of exhibits, you share a document on the screen, it makes it much more difficult, maybe because I'm getting older and I don't see quite as well, to look at a witness's demeanor or to try to just kind of see how that's going. Whereas I've got a big screen on my computer that handles multiple sort of boxes, so I can have a smaller screen where I can see the parties, the witnesses, the attorneys, etc. And then I've got another screen where I can open up my JPod, which is your version of ISIS, and I can look at exhibits that have already been uploaded. And that's a little bit easier for me to do as we're going through it. My colleagues may feel the same or different, I'm not sure. If you can stipulate to the authenticity and or admissibility of any exhibits ahead of time, certainly makes the job go a little bit easier. The hearing usually goes a little bit more smoothly. I prefer that folks don't file duplicate exhibits. If exhibit 1 is the same as defendant's exhibit C, try to just have one of those and try to stipulate to it, even as to authenticity, even if you don't agree on admissibility. Again, it just is less things for the judge to open, might make it a little bit easier. There is a recording device, as you probably know, we call it the FTR. So you have to speak slowly, clearly, and loud enough for your voice to be picked up on the recording device. Same as if you're in the courtroom, but obviously if somebody wants to get a transcript of the proceedings after, it really only works if you've had your voice picked up on the microphone that's through the system to get onto the recording device. And of course, that also means only one person should speak at a time. Please don't speak over each other. If you can spell any unusual spellings, so that if anyone does need to get a transcript later, that helps the transcriber. To the extent that you can control your internet connections and have a stronger internet connection rather than a weaker one, if you've done some WebEx hearings where a person has a weak internet connection, we get a little orangey yellow triangle, and the video usually comes in and out. And as I said earlier, if we're trying to judge credibility, it's a lot better if we can see the person and try to use that as a tool in judging credibility or weight of testimony. In my courtroom, and now well, you may know, you may not know, we used to have one judge, one law clerk. Because of budget cuts, we lost 2 of our law clerks. So now 9 district court judges are sharing 7 law clerks in kind of a pooling situation. But there is usually at least 1 or more law clerks available if you're not familiar with the WebEx technology, or you just want to try something out, to contact them and they'll give you a practice session. So, if you got a hearing coming up in a week and you go, geez, I'd really like to make sure I can, show my exhibit or do whatever you need to do, give them an email or a call, and I'm sure they can arrange a half hour or an hour for you to try it out. One caution is you're not permitted to record your WebEx hearing session unless you're given permission by the court, and you should advise any witnesses or parties of the same. The FTR is the official record of the proceeding. And so if you later try to submit some transcript that a witness or a party or you took, that's not going to be accepted as any official transcript. So I've prattled on enough. And so Judge Langer or Judge Hartman or Magistrate Collins, who wants to jump in?
I'll jump in. I want to, first of all, I want to thank everyone for your patience and your efforts to try to keep the system working in these difficult circumstances. I know it makes life harder for everyone. I appreciate your patience. I'm trying to be patient in return. I want to talk a little bit about the WebEx technology, because that's a huge part of what we do these days. It's been my experience, and I may be not no one to talk, but it's been my experience that the more, let's say, experienced a lawyer is, the more trouble they may have with the technology. But it's really important that you take the time to make sure you learn WebEx, that you, as Judge Butler said, make sure that you have good internet connections, talk to your witnesses about that. It can be very difficult to get through a hearing, certainly efficiently, when people keep cutting out. I've had that happen a fair amount, and I understand, again, I'm trying to be patient, but it makes it very difficult to get through a hearing. It's also a problem because I've had a number of hearings where people are cutting in and out and you don't get a good record. You're picking up every third word they say. And so it's very difficult to get a good record under those circumstances. So anything that anyone can do to try to make sure that you have good internet, good technology is appreciated. I think Judge Butler talked about most of the things about WebEx hearings, exhibits, etc. I guess the only other thing that I would add, I think I saw a question about criminal jury trials. We are not doing criminal jury trials until, I forget what the date is.
MLK week currently.
Right. Obviously, that's an ongoing, a moving target. Over the summer, I was involved in a committee trying to lay the groundwork to resume criminal jury trials after the first suspension. It was a lot of work by a lot of people to try to make it happen. And then unfortunately, when the COVID numbers started going back up, we had to suspend them again. So I don't think any of us have any certainty. And for those of you who don't do criminal work, the reason that's important to you is that criminal trials have priority. And so we have a huge backlog of criminal trials to get through, and our ability to do that's going to impact our ability to start doing civil jury trials again. So again, we're doing everything we can, everything within our power to try to make that happen, but there are things we can't control and we don't know what the future holds. I think that's about all I have, Judge Hartman.
Thank you, Judge Langer. And again, thanks for inviting us. It's good to see everyone. And for those who have their videos muted, I hope you're enjoying your martinis. It's been a tough year. I appreciate everyone's patience. I know that many of you have had some big changes. Lee, Lila, congratulations. John Gaddis, I know you were involved in one of our criminal jury trials. I was on the committee that Judge Langer mentioned, and we did manage to safely and fairly conduct about a dozen or so county jury trials, criminal trials, a couple 6-person termination hearings, and one felony murder trial. Unlike other counties, we've had no outbreaks traced to this courthouse, which is, I think, a tribute to everyone's care and safety. The WebEx is worse than Zoom, and it's frustrating for everyone, and I appreciate you all rolling with it. It has resulted in some silver linings. The Sheriff's Department budget for transport of inmates has been greatly reduced, as is the disruption and safety for the inmates and the sheriff's deputies. And all of you who have engaged in hearings with out-of-state witnesses, you know that that has been a tremendous cost savings as well as safety for those witnesses. However, we're all itching to get back to some degree of normalcy. Hopefully with the vaccine, there is light at the end of the tunnel, but it is frustrating. So a few of the things that I would want to emphasize is the technology piece can't be stated more strongly. Lawyers struggle, the court struggles, witnesses struggle. If you have a significant hearing, the divisions would normally be happy to accommodate a test run if you want to coordinate that with the law clerk or the CJA. Don't do that with every hearing, and every judge may not do that. But if you have a very significant hearing and you have some doubts about your technology, you can ask. The judge may not be able to accommodate it, or the CJA or law clerk may not be able to accommodate it, but we've been able to under limited circumstances. Also, just test your equipment with your friends and colleagues to make sure it's working, make sure the microphones are working, the video is working, your internet connectivity, as Judge Butler mentioned. The uploading the exhibits onto ISIS is extremely helpful to the court. It speeds the proceedings and it avoids a lot of frustration. There's often been questions about what should I wear and what's appropriate, and different judges have different views on that. And of course, it depends upon whether it's a 5-minute arraignment continuance in criminal court versus a 2-day domestic relations hearing. There's always the option, if the judge allows it, to mute your video, as many of you have figured out how to do. Since we're recording these proceedings using FTR due to our unfortunate loss of our court reporting staff due to the budget crisis, coupled with WebEx, it's critically important that the lawyers identify themselves before they speak if the judge has not done so already. So I would say, Mr. Banachak, have you run up to Netherlands yet this week? And then he would answer. But if someone just talks, especially when you have a hearing with many people, the record just won't be made. And the judge will try to catch up later, but it's not always perfect. So state your name. Keith Collins here for the plaintiff, and that'll really help the record. The judge will follow up with you. Thank you, Mr. Collins. I appreciate your argument. It's always insightful. And if the judge doesn't do that, please remind him or her to do so. In some of the hearings in criminal cases or probate cases where you have multiple parties at the same time for a hearing. The judge will have his or her own procedure for calling cases. It could be alphabetical, it could be in custody first, translator or interpreter cases first. But if you have an issue or a special request, please make that to the judge. I, for one, do not appreciate use of the chat function when we're on the record, since there is no record of the chat function, and it would be a possible ex parte communication, even if it's made to everyone. And even if it's not an ex parte communication, there's just no record of that communication. So when people try to chat, sometimes I will repeat that on the record for the FTR. But barring something unforeseen, I'm not a big fan of using that for official proceedings. Now, for a meeting like this, I think it's fully appropriate, as well as for other situations. I think we're hopeful to get back into the swing of things. The criminal trials will have a tremendous backlog. And although all of us are looking forward to having civil trials, I would hope that those who want to have an expedited trial would consider a bench trial. I know some trials are not really amenable to a bench trial, but between the 8 judges, possible magistrate jurisdiction, the chance of a quick bench trial is much higher than a delayed jury trial. That's probably all I have for now. I'll hand it over to Magistrate Collins.
Thank you. You know, the problem with going last is all the good talking points have already been covered. And so I probably just end up repeating a lot of what's been said. And, you know, thinking about what, you know, trying to nail down 1 or 2 things that I think is useful. I think first and foremost, expect that things are going to go bad or poorly on WebEx and be prepared for that. So really what that means is that you should have a backup plan for just about everything you're attempting to do. For example, don't wait till the last minute to check to see if the link that was on the notice setting works. Test that out ahead of time. If it doesn't, you can always go to the homepage of the Boulder Courts and click on the link there. If you're in the hearing and you have a bad audio connection, a judge may very well say, hey, you need to disconnect and call in. Oftentimes we're forced to do that. You need to have that phone number and login information there at your fingertips. Oftentimes it may take 5 or 10 minutes for a party or counsel to find the information and to get reconnected. Have the CJA's email and telephone number available should you run into technical issues. So just really kind of have a backup plan. Exhibits, I would have, strongly encourage you to have all your exhibits uploaded into JPOD. I agree with what Judge Butler said. I think it's a lot easier to view exhibits off JPOD. For starters, when you share it, it's often shrunk down and difficult to read. But if it's uploaded, we'll have access to it. If you need to, you can always email potentially a law clerk or CJA. So just make sure that you have all of that information, that your witnesses have that information ahead of time on an important hearing so that they can do that and keep things moving. The other thing is everything takes longer. There's often a delay in the audio, which slows things down. If you have to have an interpreter involved, it is tremendously slow at times. And so if you have, you know, a direct examination that would normally take you 20 minutes, anticipate it's going to take 30 to 45, and to budget that into what you're doing. So, and then, you know, just be patient the best you can. I know we're all kind of frustrated with having to rely on this technology, and it is always glitchy, and it's rare, I think, that any judge goes a whole day without having some sort of an issue that we're trying to deal with. So we certainly appreciate everybody's patience there. And then, as you know, I think looking ahead, and particularly with civil, and kind of following up on some of the comments about jury trials, you know, obviously we have and are continuing to build an extensive backlog of criminal cases where we have individuals sitting in custody and constitutional rights at play. What we have seen in not only just jurisdiction, but I think in every other jurisdiction around the state, is when trials open back up, while we still have to socially distance, we have very limited capacity to conduct jury trials while social distancing. And so where we could normally maybe do 6 or 8 trials in a week, that has really been, you know, narrowed down, maybe 1 or 2 district court trials during the course of a week. And so when you start kind of looking at that, prioritizing those criminal cases, and now we have a much smaller funnel to feed these cases through, it makes that court trial option much more appealing in the civil arena. I know that, you know, right now all the civil trials are continued until mid-July, but just keep in mind, as long as we're still having to social distance, I think it's going to be really tough to get a civil jury trial going until we can loosen that up some. So that's all I have. I think unless any of the judges want to pipe in on something else, I think it's now time for Q&A.
I'm going to follow up with just a few things, Magistrate Collins, and then I see we have several questions in the chat, and certainly feel free to submit more if you want, folks. A couple of things that came to mind as my colleagues were speaking. With regard to criminal trials, those who practice in that realm, you may be wondering, how was it decided and how is it likely to be decided which criminal trials do go when we only have capacity for 1 or maybe 2 criminal jury trials in a week once we start up again? And what had been happening was the district attorneys were prioritizing the cases that were scheduled on the trailing docket and submitting that list of priorities to the criminal divisions, so that then when cases got assigned to judges, it was, you know, the Smith case has #1 priority, the Jones case #2, etc. So that was their selection, not the court selection, in deciding that issue. With regard to Magistrate Collins made a comment about how sometimes examinations do last longer and that we do have a number of glitches on the WebEx, but everybody's been trying. But what has also come out of this is this has been a tremendous time saver for a lot of the parties, the clients, in terms of they haven't had to commute to the courthouse and back. So that might have helped them during a tough economic time of being able to work more hours or close to a full day, even on a day when they had a hearing and didn't feel like they had to take an entire day off. But that has also lent to having a lot of folks showing up with their backseat of their car and the camera. And of course, I always make sure they're not actually driving while they're participating. But I think it has made that, for some folks, a little bit easier. And when somebody does not have video capability, I have generally allowed them to just participate by audio. And I realize that sometimes there have been objections about, well, you can't see them, how can you judge credibility, etc. But when we're trying to get folks through a hearing with folks who may not have the resources to have the, you know, computer with the video, etc., we're doing our best to try to provide the access to justice that I think we all want to have. And then I can't remember if it was Judge Hartman, I think, talked about sort of the, whether it was clothing or other things, but also just sort of, you know, caution your clients about behavior, if you will. This is just like appearing in court in a way. And although we try our very best, all of us probably have these implicit biases that we try hard to overcome. But when you have a person sitting on a couch in their sweatpants eating popcorn during a hearing, that, you know, detracts a little bit from perhaps their credibility than if they showed up like this was a serious business meeting kind of thing. And it doesn't have to be a, you know, a suit, but certainly, you know, try to look like you're in court perhaps rather than look like you're watching the Broncos on a Sunday afternoon. So those were my additional comments before we get to some of the questions. Did any of my colleagues want to follow up with any more on that? Judge Hartman?
I think we'll take some of the questions, I guess, or I'll pass for now.
Judge Langer?
No, we can move on to the questions.
All right, and Magistrate Collins?
No, I'm good.
All right. Okay, first question, I think this was connected to one you answered, Judge Langer. Is the court conducting criminal trials to the court virtually?
All right, well, let me jump in first, and then I'll turn it to Judge Langer. I did have a bench trial during lockdown. It was in person, so the defendant had waived the jury trial and the people did not object. We had it in person in the courtroom. I have not seen or had requested a criminal trial, having rotated out of criminal during the lockdown, Judge Langer, and I don't anticipate that due to constitutional confrontation issues, which is why we're having a backlog. Judge Langer?
Yeah, I haven't had any experience with criminal court trials. And so I don't know whether they're being done in person or not. I would expect that the defense would have some serious issues with witnesses appearing remotely. I think it'd probably be a case-by-case basis and judge-by-judge basis determination, but I don't think that that's something that has come up much, if at all.
I think absent an agreement by both sides that it would be likely that those would be in person, but would still be required to follow all of the COVID protocol about masking, social distancing, etc., which we can accommodate court trials. We're pressed to cover, but we have found we can cover a 12-person jury with an alternate, etc., but that's tight. It's really mostly during jury selection. Then it gets a little easier to use some of the other courtrooms, but we're limited in the number of courtrooms we can use for jury selection just because of the social distancing guidelines that we must follow. But we're able to do it, and hopefully if the numbers turn around, we'll start doing it again in January. Second question, is the court able to set preferential civil jury trial settings for plaintiff over 70 within 119 days? And the short answer from my standpoint is no, because there's a directive that we're not doing civil jury trials until July. And so that unfortunately is the current situation, and I'm afraid pandemic trumps old age.
And if I can just add on to that, I think that that's a good point, and that when we get back to doing civil jury trials and we're weighing whether a criminal trial needs to go, that's certainly something we'd have to take into account. But right now, obviously, we're not doing any civil jury trials.
Next question, should we pre-mark exhibits with number or letter? Plaintiffs, petitioners should use numbers. Defendants, respondents should use letters. But again, we prefer active conferral and try to submit a stipulated set, or at least as many stipulated exhibits as you can. And as long as they're not double marked, in other words, you have 2 exhibit A's or 2 exhibits 3s, I don't care what you call them if they're stipulated by both parties. You guys agree or disagree?
Yeah, I agree, Judge Butler. And there's also I don't know if it's an administrative order or some judges' orders that ask parties to identify the exhibit when they upload it to ISIS. In other words, exhibit 1, a real estate sales contract. And that helps give people roadmaps, especially if there are duplicates.
Judge Langer,
I don't have anything to add to that.
Magistrate Collins?
I just follow up what Judge Hartman said. It's extremely helpful when the title of the document and the exhibit number is on the caption that's entered into ISIS, because oftentimes, as you guys know, we may have 40 or 50 exhibits, and so it's much easier to quickly find the one we need to look at.
Next question, do you anticipate that once things return to normal, that certain hearings that have historically been handled in person will now occur virtually?
Short answer for me is yes. I think that there are some silver linings to this crisis, not just the ability to binge watch Netflix. There are some hearings that probably should have been virtual or telephonic to begin with, and I can see that for me continuing if there's no objection in the right situation.
And I would say that it would be on a hearing by hearing basis. There was a time when we were doing a lot more hearings in person than we are now. And I think it was basically each judge would decide how each hearing should be handled. So I don't think we can give you a hard and fast answer, but I would expect there would be more hearings done in person.
The next question is there any estimate of a docket wait for a 7-day civil jury trial when they start up again? The short answer on that is each civil division sets a sort of approximate amount of jury trials during any trial week. And as you guys probably know, we have 3 trial weeks in a month and 1 motion week in a typical month. And a 7-dayer isn't usually scheduled much differently than a 4-dayer or a 5-dayer, but we try not to schedule multi-week trials, one that goes into a second week, either back to back or on top of each other. So each division, you'd have to have their calendar in front of you to know, is July going to be available, August, September, but you have to know what's already set in terms of, oh, there's already a 10-day medical malpractice trial set, so we're not going to double set another trial that goes more than a week that week. But as long as we have availability, we're happy to set in any time we have it open. Judges Hartman and Langer, you want to add to that?
No.
I would just add, measure your expectations, especially for client management. Even with this vaccine, it's going to take a while to return to a situation where we have 7 jury trials a week in this district, and I'm sure that's the same for every district in this state.
I'm going to have Magistrate Collins field the next one first. How have COVID protocols affected pretrial motions practice, and do you have any tips?
I haven't seen it change a whole lot. I can tell you that I think in the civil world that most of those motions are going to be ruled on based on the pleadings, that the number of hearings for pretrial motions, discovery issues is certainly down, as I think that there isn't the normal press of business with trials that we see. But other than that, I have not seen much change.
You guys want to weigh in anymore? Next question is, has COVID affected written motion practice at all? Is there anything parties should be advised of prior to engaging in written motions practice? Early on in the pandemic with lockdown, I know a couple of my colleagues who were in civil at that time seemed to believe that lawyers were sitting at home, and since they couldn't be in court, they were churning out more motions because they had to continue to bill hours and justify their existence. I only rotated back into civil in September. I don't believe I see much difference in written motion practice from when I was in civil last, which I think was 2016 or 2017. I can't recall exactly. But as far as, advised of, what should you be advised of? The active conferral is the biggest thing. The Rule 121, certificate of conferral, and really do an active conferral, not I sent them an email at 4:50, they didn't respond, so I'm filing this motion. Because then in likelihood, we get a response that says they didn't really confer. And by the way, it's all nonsense, in which case then we just back to go actively confer. And then if there's a disagreement, file the motion. We'll handle it the best we can. Please don't call something forthwith or emergent unless it really is forthwith or emergent. It doesn't help us otherwise, because we do have to prioritize those, and those do get preference from the clerk's office to get popped into the division inbox quicker. And for those who don't know, just like when we used to file paper, everything starts in the clerk's office. Just because you file a motion in my division's case, it doesn't automatically show up to me. The clerk's office is handling hundreds of pleadings every day. They're overworked, they're understaffed, they're doing the best they can, and they really are doing a good job to try to make sure everything that needs to be taken care of gets taken care of in the time that it's required to. But don't expect that just because you filed something, automatically Judge Hartman's going to see it and rule on it. It doesn't work that way. You guys want to follow up any further?
I guess the only thing that I'd add, I also rotated back into civil in September. I really don't have a sense that written motions practice is any different than it was last time I was in civil. I think there's a little bit of an impact, the fact that we don't have our own law clerks anymore in terms of our ability to get orders out. I don't think it's terribly significant, but there's something there. But other than that, I don't really see any significant difference.
Judge Butler stole my thunder on Rule 121. I've seen a sliding in Rule 121 adherence since the lockdown. You have to confer real time prior to filing those motions. And that means telephone, Zoom, WebEx. You're probably not going to do it in person. I don't want to see, nor should you want to see from your opposing counsel, the email or the text. It's like, I assume you object to this motion, right? And then, that's not conferral. And the other thing we've seen, which is a little tangential to the question, is lawyers who are thinking that because of the emergency, there's a relaxation of administrative order 10-101, which is the email filings and what's appropriate for email. Basically, it's what Judge Butler said, absent very few situations, and they're usually in criminal dependency and neglect type cases. Everything has to be filed on ISIS, and read that rule before you send an email to the CJA, who will forward it to the judge, and then that lawyer will have to answer to Rule 10-101, please.
Magistrate Collins, any comments on that last topic? Written motions?
So I'm the only, all three judges rotated into civil in September. I'm the only one that's been consistent with civil throughout this. And, there was a perceived, I think, uptick in motions pleadings in spring, early summer that seemed to then kind of subside about midsummer. So, whether that was real or that's just kind of how it perceived, who knows? But I'm not seeing that now, certainly. And I would just, again, echo the 121 referral. There are certain motion for summary judgment, things like that, are going to be opposed, right? But there are a lot of other motions where I think a good faith effort to have a discussion on the issues can be fruitful. It's pretty frustrating to get a response that says, well, had we had talked about this, I think we probably could have agreed on X, Y, and Z. And so you see things like that. And then it's also, I think, frustrating for the judges when there is kind of this back and forth about the effort made. And so it's not that much to ask. And it certainly, I think, will place your motion in a better light with any judge that's going to be reviewing it, to represent that there has been a good faith effort in control.
The final written question so far, unless people have others, is there any possibility of replacing WebEx? It's awful.
Yes, it is.
The answer is, that's not up to us. It's the State Court Administrative Office that decides what our platform is for conducting remote hearings. It is a statewide directive, so it's not anything that we in Boulder use WebEx, and Denver they use Zoom, and El Paso they use Blue Jeans. It's all WebEx. I'm guessing they have reasons for it. I don't know what they are. They don't consult with me ever before they make any decision. But, I've conducted, I believe, literally hundreds of hearings now in the last 7 months or so with WebEx. And yeah, there are some glitches, there are some problems, but for the most part, I think it's gotten the job done. I don't want to just knock it. It may not be the best system, it may not be perfect, but usually if you have folks with the good connections, if you have folks that are really prepared and can present their case pretty straightforward, and you follow some of those other guidelines about speaking loudly, clearly, slowly, one at a time, we're still, I think, at least from what little I've seen, creating at least decent records. I don't think it'll ever be as good as having court reporters, but I'm completely biased, and I will be the first to admit it. I'm also kind of afraid of certain court reporters, but that's just my aside. So Judge Hartman and Judge Langer?
Yeah, so I don't want to malign Cisco. The reason we use WebEx is it has the highest security of the 3 leading systems. At least I've been told that by our state court administrator. I've been also told that Zoom and Teams has a better user interface and perhaps some more functionality. But as Judge Butler said, the decision was made based, what I've been told, primarily for security concerns, to use the Cisco system for the teleconferencing.
Langer?
I have nothing else to add.
Magistrate Collins?
Nope, good.
Well, I know we're getting short on time, and if other folks have questions, I'd certainly entertain them. I want to thank everybody. As usual, just sort of looking out at the audience, we're preaching to the choir. We know that. You are the folks that usually follow all the rules, do what you're supposed to do, but it can't be emphasized enough. Keep encouraging your colleagues and to try to do everything to make our jobs easier so that we can try to get you guys better results even quicker. So any other questions before we close, or if our hosts have any questions that they think we ought to follow up on? What do you guys think?
I think this is Doug Stevens. I think from my standpoint, you all have covered everything very well. I think you hit all of the key points, and we really appreciate you taking the time to address this issue. I know a lot of people have a lot of questions about it, so thank you all very much. And if anyone else has questions, now's the time.
Nice work announcing your name on the record, Doug. You heard it, you learned it. That was good.
Right, just remember the WebEx recording is an unofficial recording. There wasn't a PR or any of this. You may not use it for appellate purposes. Well, if there are no more questions, I do want to thank you all. We really appreciate it. And we appreciate doing these kind of seminars because we really know that it helps us if we are able to try to help you guys a little bit. So if you have questions and concerns, feel free to bring them up and ask them. We can't always answer them, but we do our very best if we can.
Happy holidays, everybody.
Thank
Yeah,
you.
happy
Be
holidays.
safe.
Thank
Thank
you.
you.
Thank you.
Thank you.
Thank you very
Bye.
much. We so
Thank you.
appreciate it.